Okay, let's call the meeting to order. First order of business is roll call.
Okay, Representative Andrew? Here. Representative Brown?
Here.
Representative Connolly? Here. Representative Harshman?
Excused.
Representative Nyman? Here. Representative Newsom? Here. Representative Overmuller?
Excused.
Representative Summers?
Here.
Chairman Paxton?
Here. All right, welcome everyone. We have one bill to consider today, and we have our good Senator Ellis ready to present that bill. And so anytime you're ready, Senator, we're ready to listen.
Alrighty, Mr. Chairman, in the interest of time, I'll try and move through this rather quickly. I know it's an interim bill, so you should be familiar with it. But just to refresh your recollection, this bill has had a long history. It came about in a large effort because of your Select Committee on Tribal Relations years ago, was looking at the absenteeism rates on the reservation, and we wanted to better understand how we could maybe improve on that. As we started studying the issue, it became apparent that existing law statewide, our statutes really aren't working together. And so a big thrust of this bill, Mr. Chairman, starts on page 5, so I'll begin the discussion there. Under our current laws, we don't distinguish between who's at fault between a child's absence from school. Is it a habitually truant student who shows up at school but leaves midday, or their parents are getting there? Or is it a student who's, because of their parental neglect, that's the reason for their absenteeism? So what you'll see on page 5 is the distinction of a habitual truant means any child who's disobeying the reasonable and lawful demands of their guardian to be at school, versus a willful absenteeism student where this is the fault of the parent or the result of the parent or guardian's neglect to get that child to school. So with that, if we go back on page 1, you're going to start seeing the reference to Title 14-3-202. This is talking about the neglect of a child. So here we're making reference to what that neglect might mean in our Title 14 statutes. And just cross-referencing that definition, this is when you have a parent who is neglectfully not getting their child to school. So intended to be a cleanup or there. But as you move down in 14-6-402, here you're talking about your CHIN statute in Title 14. And so again, the cross-reference to this new concept of what a willful absenteeism is for purposes of the CHIN statute. And then you'll see, again, on page 3, more cross-referencing. This is something that you can, the Department of Family Services can work on, and we're just making sure that we're tying these two parts of the statutes together. On the bottom of page 3, that's where you'll see the introduction of Title 21, that's your education statutes. And here you're going to see the reference to the duties of the boards of trustees, that they shall define what not only an unexcused absence is, and you'll see the language there, but also what a habitual truant is and what willful absenteeism is. Moving on to page 4, the definition of unexcused absence is meant to encompass both of these concepts. Any unexcused absence is kind of the umbrella term, but then the distinction between one that's habitually truant versus willful absenteeism. On the bottom of page 5, you'll also see some beginning the reference to the duties of your attendance officers. Going on to page 6, and we start making some clarification, saying subject to the rules and policies of the boards and trustees, making it clear we want them to promulgate rules, not just have a policy, but that the attendance officer has a duty to consult with students, parents, and guardians to investigate the causes of unexcused absences, the habitual truancy, and willful absenteeism. Here we started making some cleanup language about what's actually happening in practice. The attendance officers to give written notice to the parent or guardian pursuant to those local board rules. We got rid of some of the prescriptive language after the second, unexcused absence, recognizing that a district might want a little more flexibility. So we say continued excused absence. The attendance officer, if they have reasons to believe that the unexcused absences were due to neglect, or something else of the child being in need of greater supervision, then it provides for the process that they should undertake in 21-4-107. We'll get to that in a second. Moving on to page 7, though, you'll see reference to the current penalty that's in place. You'll recall that right now, for a parent who is subject to the these statutes, they could be held guilty of a misdemeanor and a fine of not more than $5 or between $5 and $25. We heard extensively that, that those dollar amounts are really low and really don't provide that incentive for people to obey the law. In prior years, though, we've had conversations about increasing that to up to maybe $150, and some people felt that could be abused. The example being given, what if you have a grandparent who's raising a child because mom and dad are maybe in jail? How is, punishing a grandparent with a $150 fine going to improve their absenteeism rate? Similarly, we talked about imprisonment. Right now, there's up to 10 days in jail. And so we've discussed, how does putting someone in jail help get the kid to school? Here's where you're going to see the one change that was made in the Senate. We initially had said as a committee that the penalty would be perhaps further involvement by the Department of Family Services, either under the Child Protection Act or the Children in Need of Supervision Act. But the Senate also wanted to make sure that the courts had an additional tool. So they inserted this concept of up to 10 days of community service. Moving on to page 6, here's the reference to the process that your attendance officer must follow when they have, a student has exceeded the number of unexcused absences permitted by the district. So we clarify that it's the attendance officer, not the Board of Trustees, that determines that if a child has been absent because of either being a habitual truant or willful absenteeism, that they have a duty to notify the Board of Trustees and the district attorney. We also changed the word on page 8, line 10, to the word may, understanding that prosecutors have judicial or prosecutorial discretion. In a lot of cases, they don't initiate proceedings with courts. So we clarified and used the word may. And here's where we also made some more substantive changes. Rather than restricting proceedings to be that under the Juvenile Justice Act, we recognize that the Child Protection Act or the Children in Need of Supervision Act were more appropriate. On line 14, we also added some language to clarify, and this was an important part of the work we did in your Select Committee on Tribal Relations. In Fremont County in particular, there was confusion over which court should be notified, depending on the child's status. So here you'll see language inserted if the child is an Indian child as defined under the Indian Child Welfare Act, that the district attorney has a duty to notify the child's tribe, and that they may initiate proceedings in the interest of that child if they're allowed to do so under state and federal law. But we also wanted to clarify that if the Indian child resides on the Wind River Indian Reservation, that attendance officer had a duty to notify the Wind River Tribal Court prosecutor, and from there, the tribal prosecutor may initiate proceedings pursuant to the applicable tribal law and order codes. That was our attempt, Mr. Chairman, to recognize the sovereign rights of our partners on the Wind River Reservation. In those instances, that's where the jurisdiction turns. It's where the child resides. The question did come up on the Senate side, and I've been asked this multiple times, is there concurrent jurisdiction? And the answer is no. Either the child is subject to tribal court proceedings or they're subject to state court proceedings. So that's the bill, Mr. Chairman. Happy to answer any questions.
Mr. Chairman, thank you, and thanks for that explanation. You went through it really well. On the change the Senate made, obviously that's limiting the penalty to no more than 10 days of community service. What's the penalties that would have existed in the original bill? In other words, under the Child Protection Act, what were the range of possibilities there, just in case somebody?
Go ahead.
And Mr. Chairman, I don't have those statutes in front of me, but I think, I know members of this committee are very familiar with CHINS and the Child in Need of Supervision. I mean, that's a more intensive look when you have Department of Family Services involved, and they've got a variety of things. I think the intent with those statutes, though, doesn't tend to be punitive. I think they're really trying to find ways of assisting families. So I can't give you a good answer without looking at my statute books, and I just came a little ill-prepared today for that question.
Follow up?
Yeah, Mr. Chairman, Joe, so obviously I think, I asked that question because I do think the penalty or what could have happened under circumstances would have been, I guess, much more severe. So my question is, does the Senate think that 10 days of community services, have we kind of taken the teeth out of the bill to the point where it's not going to do us any good? That's my question.
Go ahead.
Mr. Chairman, no. I think what the Senate was looking for was just giving the courts maybe one more tool in the toolbox if they thought community service might assist as a remedy for, teaching a parent, like, you got to get your kid to school. Certainly that's up to judicial discretion. It's, may be up to 10 days. So a court can or can't. And I think that having that permissive language allows the court the ability to look at the circumstances. It, a grandparent that's really struggling to get their kid to school, or is it, a parent who's being just neglectful? But I think the real meat of it is there, and that's the reference to the chins and then the other statute. So I think I tried to keep the bill clean coming over here, but at the end of the day, I don't think that that's a huge issue as the community service piece. I was fine with it coming over here like that.
Mr. Chairman.
Vice, follow up?
Mr. Chairman, I appreciate that. But it does say may be punished not more than 10 days of community service and subject to proceedings. So I get, and we'll just dig through it and look in the law, but I don't know what that means. It could be not more than 10 days of community service and then subject to the proceedings. And I don't know what it does, but we'll figure it out.
Okay. Vice Chairman Brown.
Thank you, Mr. Chairman. Senator Ellis, one of the things that I was just looking at here is we're asking the school districts to develop rules and policies as this comes available. The effective date starts July 1. My concern is whether or not we give the school districts enough time to enact rules for the new school year to get in time. Did you guys have that discussion at all over on the Senate? I can't remember if we discussed that during interim. I'm just trying to remember, and whether or not we should give this as an effective immediately and then make sure that they have them in place by the beginning of the next school year and amend that language in.
Thank you, Mr. Chairman. Mr. Chairman, Representative Brown, I don't remember if we discussed this or not, but I can say that I don't think we need to have, this takes effect immediately and they can start rules. The more that I've been bouncing around this session, I think the preference is that once this becomes law, July 1st, there's no requirement that the districts have their rules done by then. And I think that they have the authority already to start writing rules once this passes, or they could do it sooner than that. So I don't think we need to tinker with this. I think it'll sort itself out. And, we'll need to check in eventually to make sure that districts have started moving in that direction. But there's no obligation that their rules be finalized before July 1st or by any certain date.
Thank you.
Questions or comments from the committee? Okay, seeing none, you must have done a great job, Senator Ellis. Thank you.
Thank you, Mr. Chairman. The only thing I'd add is, certainly this is an important bill. Do take a look at that 10 days of community service. I don't see it being, detrimental to the bill. I just, if there's any concerns about this, I don't want it to die on. This has been a lot of years in the works, hundreds of hours of my life. So that's all I want to add. Thanks.
Okay. Any further comments from the committee? All right, we'll open public comment. Anyone in the audience would like to comment at this time? Please come forward, state your name, tell us who you represent, please.
Good afternoon. Excuse me. Good afternoon, Chairman. My name is Travis McNiven here on behalf of the Northern Arapahoe Business Council. Really just be very quick. Certainly appreciate the past work of the Tribal Relations Committee on this topic, and then the current work more recently that the Education Committee did, and the Northern Arapahoe wish to express their support for this piece of legislation. Thank you.
Okay, thank you. Questions from the committee for Travis? All right, thank you for your testimony. Anyone else? Welcome.
Mr. Chairman, my name is Bruce Berkland, and I represent the Wyoming Youth Service Association. So we have crisis shelters, group homes, and residential treatment centers, and we would support this bill. Our experience at the present time is when we have kids in one of our group homes or something like that, we'll find out that, after they've come for some other reason, and we find out they haven't been in school for 4 months or 5 months or a lengthy period of time. And anything that could be done that one, they shouldn't end up with us around the school thing. And I think presently it doesn't come up earlier. But one of the reasons being because the penalties can be stiffer or whatever. I don't think they get pursued or prosecuted. And I see this as being very helpful just in terms of getting people involved earlier and getting something going without kids ending up. We don't perceive this would add kids to what we do, but would get them help and involved in school earlier. With
Okay,
that, I'd
thank you.
stand for any questions.
Questions from the committee? All right, thank you for your testimony. Anyone else? Anyone else? Do we have anyone online? Okay. I guess you did see we have Representative Overmuller now online, okay, so we can count him present, and Representative Harshman also. All right, good. Go ahead. Please tell us who you represent.
Good afternoon, Mr. Chairman. My name is Corin Schmidt, and I'm the Director of the Department of Family Services. And I heard Representative Summers' question about the Child Protection Act and the CHINS Act in relation to what kind of punishment would be available. I can't speak directly to the amendment that the Senate provided, but certainly filing a petition in juvenile court for a CHINS case or a protective services case is a high level of government involvement. So community service at that point might be a nice alternative. If there is a petition filed in juvenile court, then certainly that family under the Protection Act does come with a case plan. There'll be a lot of observation and certainly requirements about fulfilling the case plan. With that, though, comes services, as is the case also with CHINS. So I'm available for any questions. I appreciate this bill. Educational neglect over the years has been very confusing. So I think this goes a long way to establish a better definition and certainly more statutory guidance for the prosecutors, for the schools, and for DFS.
Okay, thank you. Questions from the committee? Anyone? All right, thank you for your testimony. Do we have anyone else online? Anyone else in the audience would like to comment? Anyone else? Okay, public comment is closed. Committee, what's your pleasure?
Move the bill, Mr. Chairman.
Moved by Brown, seconded by Nyman. All right, open for discussion. You want to go through it page by page, or do you feel comfortable with when Senator Ellis went through page by page pretty much with us? So,
Mr. Chairman, yeah, I think she did a good job running it through page by page.
okay,
Mr. Chairman, I originally shared the same concerns looking at page 8 or I'm sorry, not page 8, but page 7. And what that does, but the more and more I read it, if you try to get away that stricken language and you try to just read it as it would read, they may be punished by not more than 10 days and subject to the proceedings underneath this. Director Schmidt provided us some good testimony that, you know, that's what they may be punished with. I actually think that the community service is a good carrot out there. You know, one could argue that the $5 and $25 wasn't enough. Maybe you think that this isn't enough, but I agree with the senator that this is another arrow in the quiver for the prosecuting attorney if they so choose to recommend a sentence if they need to. And this is certainly not one that's punitive in nature and provides a good level of guidance for the parent.
okay, thank you. Any other comments?
Mr. Chairman.
Yes, Representative, go ahead.
Thank you, Mr. Chairman. I too look at that new language as actually almost 180 degrees difference in tone than Representative Summers, where I think the Senate, what they did is that they actually added a punishment possibility where we had taken it out, the $5 and 10 days, whatever. They added that punishment and then the proceedings, which are pretty strict. Thank you.
Mr. Chairman.
Go ahead.
Mr. Chairman, thank you. I agree after reading it. I think the language is clunky. I don't know if anybody else would agree with me, but I'll run it by one of our attorneys and just see if they can tell me what it really means.
Okay. Anyone else? Are you ready for the question?
Question on the bill?
Okay. Roll call, please.
Okay, Representative Andrew. Representative Brown. Representative Connolly. Representative Harshman. Representative Nyman. Representative Newsom. Representative Obermueller.
Aye.
Representative Summers.
Aye.
Chairman Paxton.
Aye. And Vice Chair Brown has agreed to floor manage. Any other business to come before the committee? All right.
Mr. Chairman?
Okay, go ahead.
Committee members, if you guys get a chance, start looking at the K through 3 reading assessment. I believe we're probably going to see that sometime next week, right?
Monday.
Be prepared if you have any amendments coming into next week so we can have a little bit more thorough and thoughtful discussion instead of trying to do them on the fly. Try working with LSO attorneys. If you're going to have anything, have it presented for the committee to consider, I believe probably next Wednesday.
Well, I think maybe Monday.
Monday?
Yeah, that's, we've delayed it long enough, I think, and given people, we'll give them the weekend. I think that's probably enough. We'll consider it on Monday. Okay. Any other business? All right, thank you. Meeting adjourned.